Please rise. Justices of the Appellate Division, Supreme Court, First Department. Be here, you will present the business of the Appellate Division. Draw near, give your attendance, and it shall be heard. Please be seated.
Good afternoon, and welcome to the Appellate Division First Department. You all know our routine. We are familiar with the record and your briefs. So please ask for the time that you need, not what you want. Currently, we have over 6 hours of argument time. I'm sure you don't want to be here that long. So if you ask for what you need, then I won't have to do it for you. Okay. People versus Wayne McBain. 5 and 2 and 5. Sutherland versus Tudor Perini. 5 and 2 and 5. SM Dazareth is submitted. Benitez versus Patel. 4 and 1 and 4. Vargas versus Baldakar. Do I have a respondent? Would you still like to argue, or would you like to submit?
If I may, very.
Okay, I'll give you 4 minutes. Madison Square versus Atlantic Specialty.
Deputy Judge, 4-4.
Respondent, Philadelphia, 2.
Okay. So let's do 4 and 3, 2 and 5. Okay? People versus Bryce Zimmerman, submitted. Friedco Capital versus Carlton Fields. You have no respondent. 4 minutes. Dow versus 16 Sutton Place.
4 and 2, please.
4 and 2 and 4. Robbins versus 315 West 103rd.
Your Honor, appellant request 6 and 2. Respondent, 5 minutes.
4 and 1 and 5. Alexis versus Gary T. Submitted. People versus Angel Cabaret. Submitted. Heritage Funding versus Doyle Brothers.
Appellant request 4 and 2. Respondent request 5.
4 and 2 and 5. Saeed versus Shaikh.
Appellant 5 and 2, Your Honor.
You have no respondents, so what would you like to do?
Brief argument. 4 minutes would be enough.
4 minutes. People versus Kamar James. 5 and 2 and 5. La Porta versus PPC Commercial.
Appellant request 3 minutes. Respondent request 5.
3 and 2 and 4. 274 Madison Company versus Vieira.
Appellant 5 and 2, please. Respondent request 5.
5 and 1 and 5. Maltese versus Port Authority is submitted. First case on the calendar, People versus Wayne McBain. You may proceed.
Thank you, Your Honor. I'm Benjamin Weiner on behalf of Mr. McBain. The prosecution's case here depended upon the shaky eyewitness testimony, which was cross-racial, of a person who barely knew Mr. McBain.
He knew him just fine. He lived in the same building. He was one floor above him.
This was a large apartment building. There were 7 stories, 20 apartments on each floor. And again, this witness, the main way he claimed to know Mr. McBain was that Mr. McBain, he said, had a dog. That wasn't true. Mr. McBain didn't get a dog until after the identification.
Well, does it matter if he owned the dog or if the witness simply saw him on a number of occasions walking the dog?
Well, again, what the witness testified to was that it was always the same small dog, and Mr. McBain didn't get a small dog until after the fire. But in any event, this identification was made through a peephole. This is not a reliable basis to see somebody who you've only seen in passing. And again, to make a
Counselor, if I may, the witness indicated that he saw the defendant several times per week. He named him as Anthony, and that was the same name that defendant had listed on the Miranda warnings. And also that while he didn't know his room number, that he lived on the 7th floor and that the apartment was not directly above his.
Well, again, Your Honor, he knew Mr. McBain's first name. That is hardly a basis to know someone especially well. And again, given the sort of impoverished way in which he claimed to view Mr. McBain, which was through his peephole.
So going back to the peephole, peephole was shown to the jury, and I know that you have concerns about that, but presumably it was shown to establish that, in fact, you can see through the peephole. It's not a funhouse mirror.
Well, I think this is a crucial point, Your Honor, because the jurors were able to pick up that peephole and hold it up to their eye like this.
But wasn't it only offered to show that they could actually look through it, that in fact it didn't have moisture, things like that, to be able for Mr. Cho to make the identification? That
may be the case, assuming it was in the same condition it was actually in at the time of the fire. But in any event, they were very likely to overestimate their ability to see through it. They were able to pick it up and hold it up to their eyes, as opposed to the eyewitness who looked through it like a peephole, as it was fixed in his door and at a slight distance. And that just isn't the same. And that actually provides an independent basis for reversal, that peephole never should have been admitted, because the jurors were likely to substitute their own advantaged view for what the evidence showed, and that also undercuts the reliability of the identification here. And also, there was this surveillance video in this case, and this was really quite dramatic. This video showed a person who could not reliably be identified as Mr. McBain at the scene of the crime, and who the prosecution initially tried to show could not be identified. And it was only after the fire marshal was confronted with this video and said, there's nothing of significance on it, i.e. it's not Mr. McBain on that video, that the prosecution does this radical about-face days later and changes their position and says, oh, actually, this is Mr. McBain. But there were problems with that as well that depended on matching up Mr. McBain's phone records with the phone usage of the person in the video. And if the fire marshal had been wrong by 2 minutes about this timestamp, which he admitted he was estimating what the actual time was, those records wouldn't have matched up and would have exculpated Mr. McBain further. So there was real reason to doubt this. And also, the complainant in this case never testified. This was highly unusual as well, and meant that the prosecution couldn't establish that the perpetrator had unlawfully
Well, the
entered.
complainant wasn't a witness.
But that's
So
true.
outside of confirming that that was a room assigned to him and that the contents within the room belonged to him, that's all that witness could testify to.
I disagree, Your Honor. That witness could have testified whether Mr. McBain had permission to enter his apartment. The jury was left to speculate as to whether or not Mr. McBain was allowed to go in there, whether or not...
But how is it speculation? Because according to Mr. Chow, there was banging on the door, which suggests, doesn't it, that in fact there was nobody in there, and then he walks in.
Well,
If
not,
he had permission to go in, he would have just walked in.
may I answer your question? Your
I'll
Honor?
allow it. Go ahead.
Thank you. This person was going into this room to set a fire. He was going to check if there was a person in there, whether or not he had permission to enter. So the fact that he's banging on the door and asking, is this person home, doesn't show that he did not have permission to enter. Those are two distinct elements of burglary.
Okay, thank you. You'll have time on rebuttal.
Thank you, Your Honors.
Counsel?
May it please the court, Beth Fish Cohen for the people. The majority of the issues related to whether the defendant was properly identified were fully addressed at trial. But there is one issue that is entirely new that's being raised on appeal, and that is whether the people changed their theory about the video, or potentially worse, whether the video actually suggested a different perpetrator. We've already sent up to the court the video clips, as well as some of the stills, and I think you'll be able to understand why this wasn't originally introduced. You can't see the face, but we never changed our theory, and I am providing today, either directly to you now or to the clerk, the additional evidence of the defendant's pictures, which we had not previously submitted, but which I think it's pretty clear to say that while you can't by any means convict a defendant based on this, to suggest it is a different perpetrator is pretty much a stretch, I would imagine. All the other issues, as I said, were fully raised before the jury. They chose to credit the witnesses. They saw the way both the video, the phone records, everything fit together.
How do you address your adversary's point that with respect to the people, that it was error to admit because what the jury saw was under different lighting conditions, et cetera, which prejudiced the defendant?
Sure. Well, obviously, a peephole is a very ordinary object. And this court has talked about when the juror can use its own real-life experience to look at it. The only objection was whether, it was a different lighting, different context. They had the peephole. There's no question that a peephole goes through the door. The entire cylinder was submitted, and they were able to look through it and see it. Is it slightly different? Perhaps, but certainly no more so than what this court has allowed by looking through binoculars or to allow a gun to drop in the jury room to see the sound it was made. This certainly fits within the type of evidence and the manner in which this court has routinely allowed jurors to see exhibits during deliberations. If there's no other questions, I'll rest on my brief for the remaining points.
Thank you so much. You may proceed. You have 2 minutes.
Thank you, Your Honor. There was absolutely a change in theory in this case. It was the defense who first brought up the video. This wasn't part of the prosecution's case. The prosecution had already at that point introduced evidence to try to establish that the perpetrator could have gotten to the room completely evading the surveillance video. And the questions on redirect after the fire marshal was questioned by the defense about the video sought to establish both that the person couldn't be identified on the video, and even, and this is something the prosecutor almost certainly knew was not the case, that the video didn't definitively depict the night of the fire. So they clearly were trying to undercut the significance.
Did not what? Did not depict the night of the fire?
Yes, Your Honor. The prosecutor asked the witness, is the timestamp on this video off by 14 hours and 37 minutes one way or another, suggesting that the video could have been slow or fast real time, that timestamp on the video, and that it may not have depicted the night of the fire at all. Of course—
Wait, you're saying suggesting, you're suggesting. Where in the record does the prosecutor suggest that?
I'd urge Your Honors to look at pages, hold on, 261 to 262. The prosecutor asks, is the video off by 14 hours and 37 minutes one way or another? And then asks Hetwer, the fire marshal, after he agrees, it could be off by 14 hours one way or another. This could be 11 in the morning. And
Okay.
this could be 11 in the morning, and the fire marshal agrees.
But what you said was that somehow was evidence that either the system wasn't working, et cetera. It could just be that the time is off.
Right, and what the
That doesn't mean the equipment isn't working, it just means that the time is not accurate to the time of recording.
my point, Your Honor, is just that the prosecutor was trying to elicit testimony that the video may not have depicted the night of the fire at all, because it could be fast or slow to real time. That was the purpose of asking the fire marshal those questions, and it wasn't until after a recess that the prosecutor decides, oh, this is Mr. McBain in the video, that they elicit testimony that you can actually see firefighters in the video, so it clearly is the night of the fire, which is all to say there absolutely was a change in theory here on the part of the prosecution.
Okay. All right, thank you so much. We have your brief.
Thank you, Your Honors.
Thank you. All right, Owen Sutherland versus Tudor Perini.
Good afternoon, Your Honor. Anthony Malecki appearing for the appellants. And I would like to start out by acknowledging that in our opening brief, there are two arguments that we make. And I do believe the first argument that we make into why this court should overturn the summary judgment decision is stronger than the second. And I think the sole proximate cause argument is the reason why this court should overturn the lower court's decision. I think this follows in the line of cases such as—
How can you say that it's the sole proximate cause of the plaintiff here when his direct general foreman told him to move the rebar notwithstanding the rain?
I don't believe that's the direct testimony that was in this case.
Actually, it was on page 102 of Mr. Sutherland's EBT. He states that he requested a crane, was told that the crane was busy by Ian. He was asked whether he asked his general foreman, Mr. Bernstock, if he can wait until the crane isn't busy, and his answer was, just give me the effing steel.
That response is into whether they should use a crane as to whether carrying the rebar itself, which is not the issue in this case.
No, the issue is whether he ignored the dangers of the rain and decided to move the rebar manually of his own accord, or whether he was forced to do so because his general foreman told him, move the rebar, I don't care that it's raining.
But that, respectfully, Your Honor, there is no timeline in that deposition, in that testimony.
It's
as to
very
when
clear. He says, it's raining. I asked for a crane to move these 110 to 120 pound rebar to lower them. He asked for a crane to move all of them at one time. And he was told the crane was busy. And when he asked whether he could wait until the crane was available, he was told to move the effing rebar, to move the steel. So how, under that fact pattern, can he be the sole proximate cause?
Your Honor, I just disagree that the timeline says that he informed his foreman at that time that it was raining at that moment. We don't know that it was raining.
Because his foreman can't look outside and see that it's raining.
Where in the I don't believe anywhere in the testimony that it says it was continuously raining at all moments of all day, or that that rain was what was at all times.
Well, if it wasn't raining at all times of all day, then how can you say he's the sole proximate cause?
Because at the time that he slipped, it was raining, and he acknowledges that it was raining when he slipped.
But he had only moved, like, he was in the process of moving, I believe, the third rod of steel when he fell.
I believe he said like the
slipped
fourth
and
or
fell.
fifth, but
Well, so we can assume then that it was about the same time that he requested from his foreman if he could wait to move the rebar.
Counsel, when you're answering that question, are we weighing evidence here, making these decisions based on the questioning?
I mean, based off of the question, you seem to be focused entirely on the plaintiff's testimony. But like I said, the plaintiff's testimony does not have a timeline as to when the crane was asked, when the rain started falling, and when the gantry became slippery. There were several hours that he was working in this area before the accident happened. It took them a lot of time to remove this rebar. He could have asked for the crane 2 hours before the rain became heavy enough where there was a slippery issue. So I don't believe that that goes to the issue of whether it was the plaintiff's call to continue doing the work. He was the foreman in charge of his crew in that area, and the only one in
But he had, counsel, we've read the record. He was not the top foreman on this job, and you know it. Mr. Bernstock was his general foreman, and he was taking instructions from him.
Certainly, but we
Tell
don't...
me where in the record Mr. Bernstock says anywhere that he was asked and was ready to provide a crane.
And I acknowledge that, but Your Honor, there is still testimony from the plaintiff that he was the one responsible for instructing his crew in that area. I understand that he has a boss.
Is there any evidence one way or another about his interactions with his foreman on that day?
Other than just that testimony about the crane, there are no other testimony about...
That's the only reference in all the testimony about any interactions he had with the foreman that day.
That's my memory, yes.
Isn't it in the record that he took his instructions from Mr. Bernstock on a daily basis?
As to the crane, he certainly continued to work
As
without
to
a crane.
his work, as to the work that he was supposed to be doing?
I mean, he acknowledged that his general foreman would tell him what his job was for that day, but not specifically how to do that job.
Maybe not how to do it, but he received instruction from the foreman. And on this specific day, he asked to do the work in a certain way by the use of a crane, and he was told, just get me the effing steel.
And that is what the testimony says. I just disagree that that involves the rain aspect and the...
Is there any controversy? Where in the record does Mr. Bernstock talk about that statement and give us a timeline, since you fault the plaintiff for not giving the timeline at an EBT where the defendants are asking the questions?
There is not that testimony about Mr. Bernstock's statement, certainly not from him himself, but...
So all I have is uncontroverted testimony by the plaintiff. No one contradicts him. No one. And if there is something in the record that contradicts him, please tell me, because I want to see it.
Well, my position was just that the testimony regarding the crane had nothing to do with the slippery or the
It
wet.
had everything to do, because moments after he fell, they got the crane. But we'll hear you after your adversary.
Thank you.
Am I missing something?
No, you're not. May it please the court, Cy Aidner for the respondent. The one thing that we tried to address in our briefing is that the moment this general contractor takes the position, we don't know if it's too dangerous that day, sole proximate causation is gone. The reason why it's gone is Tudor Perini testified they expect these people to work in the rain. Tudor Perini testified
Counselor,
this happens. If it goes
Counselor,
too far,
Counselor, how many workers were under Mr. Sutherland?
multiple, and there's
How
no
many?
question.
25, 30, 40?
Correct, and he had discretion that day.
And what were his responsibilities with respect to his crew? Was he responsible for the safety of his crew, yes or no?
There's no question that he was.
Okay, it's raining.
Yes.
Should he be telling his crew at that point, we got to be careful carrying this rebar, those kinds of things?
Here's, the answer to that question is no, and let me say why. There's a certain amount of discretion that Sutherland has, just as Tudor Perini has acknowledged. These people are supposed to work in the rain. They're expected to work in the rain. If Tudor Perini doesn't take the position in this case that it was too dangerous, what is the basis for a jury to infer that what Sutherland did was the sole proximate cause?
Why isn't it part of his job as a foreman to be able to make the determination on his own whether or not it is too rainy to continue working or not working?
That's a question I can't answer, but that is the testimony in this case.
Isn't that the heart of this case? Who made that determination? Once it started raining and it started getting slippery, who gets to make that determination on that particular day whether or not he should continue working?
Based on
Doesn't
this
he
record,
get to make it, or isn't there at least a disputed issue of fact whether he could make that decision based on him being the foreman directing that particular piece of work?
respectfully, no. The reason being is that Tutaprini ultimately has final say over this job site. If they wanted to overrule Sutherland, they were
Right, but is
obligated
there
to do
any
so.
evidence, I know there was discussion about the crane, but it isn't clear from the timeline, the crane or lack of crane was not what caused the slippery condition. The rain caused the slippery condition.
Correct.
So is there any evidence that on that day there was any discussion with anyone else about whether he should continue working or stop working once it started raining, and whether it was slippery, and whether he had the ability as a foreman to say, I don't want to work anymore, it's too slippery?
There was no discussion.
Okay, if there was no discussion with anybody else, then why wasn't at least an issue of fact as to whether it was his decision as the foreman to keep working, even though it was raining and getting more slippery?
Because he has a certain amount of discretion to work in the rain, once Tutaprini, who controls that job site, says, we don't know if it was too dangerous.
Right, but forget about, if there's no discussions between him and anyone else, then why is it relevant what they thought or didn't think? Wasn't that his decision as the foreman
No, because,
to make?
right, because the issue is that there's no basis to infer that he misused his discretion given the history of that job site and there was no
Counsel,
express...
forget the history of the job site. Did I cite the record correctly that his general foreman
Yes.
told him to move those rebar regardless?
Yes,
Was it raining at the time?
yes, it was.
So what are we talking about here? Did he have the ability to say to his general foreman, no, it's too dangerous, I'm not doing it?
No, not on this record.
So he had no discretion. In other words, it could be hailing, and he has no discretion. A man who's responsible for 25 to 40 workers to stop dangerous conditions. Is that your position?
Correct, because he's not the ultimate boss.
So in other words, it could be pouring rain, lightning, and he has to continue working because the boss says you continue working.
Correct.
Okay.
And with respect to the integral defense, I mean, I think they've taken it too far. Remember, because he strikes piping under these circumstances, which is preceded by a slip and a slide based on the industrial code violation, this really is a superseding causation argument, which they don't brief. Unlike a situation where if Sutherland was walking and he tripped over the pipe, and you'd have a direct integral defense, here it's secondary or tertiary at best. And
I think your adversary essentially conceded that.
fair enough, Your Honor. If the court has no questions, may the respondent rest on his brief?
Thank you.
Thank you.
Counsel, you have 2 minutes.
Thank you, Your Honor. I will point out that in the testimony on page 26 of the plaintiff's deposition, he does recognize that he knew what his job was that day when he arrived to work, so he did not have to have any discussions with his foreman in the morning.
No, I know. He absolutely said that some days, if the work continued into the next day, there was no need to get any additional instructions from his foreman because he knew what he had to do. But that's not the issue here.
Right. The issue is really who was the controlling, who had the decision-making authority, and whether there's evidence that the plaintiff had decision-making authority, which I would submit that our client's testimony that he was the lather foreman and he was the person at the site that they would rely on.
So you're saying this gentleman had the right to tell his general foreman, no,
Yeah.
I'm not going to get the steel. I'm waiting for the crane. He had the right to do that.
If it was raining outside and there was a
And
slippery
where
condition,
in the
yes.
record does it say that he had the right to override his general foreman?
Well, our client, who is the general contractor, testified that he was the person that they would rely on to make the decision. That
Who,
if they
Mote?
went to him,
You're talking about Mote?
yes,
Mote, who testified that workers were expected to work in the rain, that they had to do this quickly because the work has to be done fast. That one?
I
mean,
I don't believe that's what he
goes on
testified.
for pages in this transcript about how fast they had to work. They were expected to work in the rain. He goes on for pages about that.
I don't believe that's what he testified to, Your Honor.
Okay.
I believe what he said was that at times, depending on the conditions, there are jobs that could be done in the rain at times, different jobs, but that iron workers specifically, anything weather-related would be dangerous to them. And if they were told, as the general contractor, that they could not work in those conditions from plaintiff, the foreman himself, they would have stopped them.
Didn't they have a safety manager on site?
Yes.
And what was the job of the safety manager?
I mean, also to oversee and
And
the
to
safety
stop the
issues on
work
site.
when the conditions were unsafe?
They certainly, both the general contractor and the safety manager certainly had the ability to stop work.
Did the safety manager tell Mr. Sutherland at any point, you can't work under these conditions?
There's no evidence in the record of that, Your Honor.
No. Okay.
Again, did Mr. Sutherland have the authority to stop the work, Counselor?
Yes.
Thank you.
Thank you, Your Honor.
Benitez versus Patel. You may proceed.
Good afternoon, Your Honors. Gregory Casino for the defendants' appellants, Dr. Patel and Praveen Kumar. I'm sorry, Dr. Kumar and Praveen Kumar, Podiatry PC. Your Honors, it's our contention that the claims against Dr. Kumar should be dismissed because he didn't have a duty of care to the plaintiff. The plaintiff was solely treated by Dr. Patel. It was Dr. Patel's patient. Dr. Kumar and plaintiff never met. Plaintiff didn't know who he was, and Dr. Kumar did not participate in plaintiff's treatment with Dr. Patel. Would also point out that there was no direct legal relationship between Dr. Kumar and Dr. Patel. Dr. Kumar did not personally employ Dr. Patel. Rather,
That's a little murky, right? Isn't that a little murky as to what precisely their relationship is?
Well, Your Honor, this practice, this Praveen Kumar Podiatry PC was operated as a PC. The plaintiff's position, I guess, essentially is that Dr. Patel was an employee of the PC. But that's very different than saying that he was employed directly by Dr. Kumar. Again, this was set up as...
So would you concede maybe there's a stronger argument with respect to PKP?
I would concede that that there would be a stronger argument and I would concede that all the factors that the plaintiff points to go to the issue of whether or not the Dr. Patel was employed by the group. I would concede that that's what I don't agree with either of his arguments, but I would concede that that would be his stronger argument.
Making two separate arguments. So your argument as to Dr. Kumar is that he did not personally give any medical care, and your argument as to PKP is that the relation-back doctrine shouldn't apply.
Yes, it's
So they're separate arguments. You're not arguing that as a matter of law he was not employed in any way, or are you, by PKP?
Well, we can see, when the plaintiff made the relation-back argument, the plaintiff had to show that there was some merits to these claims, and we would take the position that the Dr. Patel was also not an employee of the PC, but our main argument with regard to the relation-back doctrine is that the plaintiff was aware of the existence of this PC for a very long time.
For how long?
Well, it's in the plaintiff's medical records, the name of the PC.
But doesn't plaintiff say that he didn't have the records and so therefore he didn't know?
Okay, and I understand that that's the plaintiff's position, but the plaintiff got it at some point. It was also discussed.
So in the light most favorable to plaintiff on your motion for summary judgment, isn't that an issue then?
Well, this is the plaintiff's argument. This is the plaintiff would have the burden on the relation-back doctrine here. We're not talking about us moving for summary judgment.
But putting that issue aside, is it a fact that in fact plaintiff at least for a year and a half knew about the existence of PKP?
Absolutely. At the very latest, if you want to accept everything that the plaintiff says, he learned about the existence of this PC during Dr. Kumar's deposition testimony. He made clear about the PC that there was a structure, and if anybody employed Dr. Patel, which again, we take the position that Dr. Patel was an independent contractor. I'm happy to discuss those couple of pages in Dr. Patel's deposition transcript where at first he says he's employed, but then the plaintiff's attorney really explains the difference between a
Counsel, if we
direct.
accept your argument about the relation back, though, we don't need to decide that issue.
Exactly, exactly.
Remain, because that's not what the relation back argument hinges on, correct?
Exactly, but what I would just say is, right, so getting back to Justice Singh's, I'm sorry, I was flopping back and forth a little bit there. I would just say that, yes, he knew about it since, I believe it was in September of 2019. He didn't do anything with this information for, I think it's like another year and a half at that point. It wasn't until we moved for summary judgment, and then all of a sudden takes a position, oh, now I want to bring the practice in.
And what do our cases hold with delays of this kind?
That you know, in order to rely upon the relation back doctrine, you have to show one of the elements is that there was a mistake. And then the Baran case in the Court of Appeals, I cited numerous cases from this court, including a very recent case from a couple of weeks ago, where both Justice Manzanet Daniels and Justice Mendez were on the panel, saying that there has to be some sort of, that's the C&J Brothers versus Hunts Point Terminal produce. I cited to that in my reply brief, that there has to be, you know, a reasonable mistake. And if you know about it and you don't do anything about it, you can't later look back and rely upon the relation back doctrine. So I would just say that by sitting on this information, by being aware of this information for all this period of time, not doing anything about it until we move for summary judgment on behalf of Dr. Kumar, and then all of a sudden, you know, trying to rely upon the relation back doctrine, that's not a proper use of the doctrine, and that should have been denied. The plaintiff's motion should have been denied.
Thank you.
Is there any further questions? Thank you.
May it please the court, Mark Gertler for the respondent. With respect to the issue of summary judgment, I think counsel was telling you what he'd like the testimony to have been, but it just wasn't that. Dr. Kumar said Dr. Patel rather said he was employed by Dr. Kumar. He took instruction from Dr. Kumar. These were Dr. Kumar's charts. He used Dr. Kumar's staff.
Where is there anywhere in the record where it said that Dr. Kumar was somehow involved in the care of this patient, whether behind the scenes or in front of the scenes? Where in the record does it say, and what does it say?
Well, there are two things. One is he said generally he takes instruction from Dr. Kumar, and the other is there is a note in the record where Dr.
Instructions are like you're going to see a patient this day, or instructions about a particular, I mean, to be held liable personally, there has to be some evidence that he somehow treated this plaintiff, and that's what I'm asking you. Is there any citation you have to the record that supports your claim that he was actually treating this plaintiff?
The only thing that suggests any actual treatment is that he ordered medication for him.
And that's the only thing?
That is the only thing.
Are there any claims here with respect to improper medication?
Yes, it's in the bill.
With respect to particular medications that Kumra?
Actually, yes. I think it's called Regranix.
Was the medication ordered by Dr. Kumra, or was it simply submitted under his office's letterhead?
It's got his signature.
He had his signature.
And I think it's
Was he
paid.
asked at his deposition whether he had any involvement or any decision-making with respect to that prescription, and whether or not it should or should not be?
Unfortunately, it was not asked in the deposition.
So the only thing you have is the signature on the prescription, and that's the basis for personal liability.
Right.
Okay.
Counsel, I was under the impression that Dr. Kumar had submitted a request for insurance approval for a medication, but Dr. Patel had testified that he was the one that prescribed the medication. I thought that was the evidence.
That's right, Judge. That's right. If I suggested otherwise, I misspoke.
Now, going back to PKP, your adversary says, of course, you've had the medical records, plaintiffs had the medical records for many years, and I would submit at least you would agree that for a year and a half or so, you knew about the existence of the corporation, right?
The case law is clear, Your Honor, that the passage of time does not constitute prejudice.
No, but it goes to the third element, doesn't it? Aren't there cases that say if you wait too long, and then the defendants essentially, believe it's not a mistake, that they're not going to be sued? Aren't there cases?
There are some cases in which the statute of limitations expires in the interim, and the court finds that they let the statute expire while this was going on. Statute had long expired at the point where we first learned from Dr. Kumar that he had a corporation which he solely owned.
So if the statute of limitations already expired, you can wait 5 years then, and that's fine?
Well,
As
this
long as the
isn't,
statute's already expired, then there's no time frame which you're required to bring this application?
I don't think there's a bright line test, Judge, but
Isn't that even more prejudice? I mean, the whole idea of a statute of limitations is to have repose, and if you could just wait forever and argue, well, the statute already passed, wouldn't that defeat
you
the
know,
purpose?
in this case, respectfully, it's a little different because there are cases where, like, the city is sued or a hospital is sued, and then the plaintiff wants to bring in a specific doctor or a specific police officer, and the courts have held, well, the statute's run, and there's no reason this person would have any, shouldn't have put this behind them.
But why wait till after he made a motion for summary judgment to first bring this application? Isn't that a little late?
Well, I agree that it should have been done, but I disagree that it's legally late. I think the case law says, again, that the passage of time, it's got to be prejudice, and the passage of time doesn't constitute prejudice.
Thank you.
Thank you.
Vargas versus Baldakar.
Rebuttal.
Oh, I'm sorry. Forgive me.
You don't need it.
God, forgive me.
I apologize, I didn't stand.
No, you have nothing to apologize. I cut you short, and I apologize.
Thank you.
Please
Can you address your adversary's position with respect to the relationship back doctrine, that there's no prejudice here, and which is probably correct, but is he right in his analysis?
I would submit no, Your Honor. I mean, as Justice Kern noted, like, yes, then what is the standard then? If you could just sit on this information and not do anything for a very long time? I acknowledge that the statute, if you take the September 18th, 2019 date, the date of Dr. Kumra's deposition testimony, as the date that all of a sudden he finally woke up. I mean, we would take the position in our answer, Dr. Kumra identified the fact that there was a practice that he owned. But if you take that date, I mean, if then the standard then just becomes you could sit on this information and never have to do anything with, I would submit respectfully that that's completely contrary to what the cases are talking about, that it's not prejudice. Prejudice, you know, any alleged lack of prejudice, that should not be dispositive. It's really the fact that they're looking for a mistake. You need to show that you made a mistake, and if you're aware of this information and do nothing with it for a very long time, it's extremely hard for them to argue that they did in fact make a mistake.
Thank you.
Thank you, Your Honor.
Vargas versus Baldakar. You may proceed.
Good afternoon, Your Honors. May it please the Court, Nicholas Tam from Schaub, Omni, Sutra, and Spratt, representing the appellants in this case. The motion court should have granted the defendant's summary judgment because this case deals with cardiology standards of care, more specifically cardiac clearance, a screening assessment that the plaintiff's expert has never performed. On one hand, the defendant's expert, Dr. Mark Goodman, has over 40 years of experience in cardiac care, including as the chief of the coronary unit for the Navy in Pensacola. Plaintiff's expert is a gastroenterologist with no experience in cardiology. In fact,
an internist.
Yes, Your Honor, also an
And
internist, which is more of a general specialty, is more of a general practice area, and is apples
I
and
think internists would take exception to that characterization, but continue.
Yes, Your Honor, I understand, but in this case specifically, where the gastroenterologist specifically requested the clearance of a cardiologist, he didn't request the opinion of another gastroenterologist or another internist. This case dealt with Coumadin, which is a blood thinner. In the plaintiff's expert affirmation, he or she never opines the following: that he performed a cardiac clearance, that he or she has prescribed Coumadin, that he or she is familiar with INR values. These are the issues that are germane to this case. And in the absence...
You see, I take issue with that because I don't have a problem with the doctor's affidavit on those issues. I think that that was clearly set forth. If you want to take issue with their lack of commentary on its relationship to cardiac patients, that I think is a valid, but to say that an internist doesn't know what Coumadin is and what that's used for, quite frankly, is ridiculous based on this affidavit.
Understood, Your Honor. So I'll go to that point. The plaintiff's experts' statements and opinions are conjecture because they're not based on facts and citations to the record. And I'll give you a few specific examples. The defense expert stated that this patient was in stable cardiac condition, cited specifically to the patient's clinical status, vital signs, and scrutinized the EKG and echocardiogram, results showing that this patient had a functional mechanical aortic valve. In a conclusory fashion, the plaintiff's expert merely says this patient was high risk. Well, based on what exactly?
Well, counsel, even your own expert says that this client was high risk.
I would disagree with that characterization. I would say that
Typically, you don't need a cardiac clearance for a colonoscopy. For surgery, sure. A colonoscopy, not unless there is a cardiac danger, right? Which this woman clearly had, having had an aortic valve replacement. So there's no question about that. It seems to me that the strongest argument is that this expert failed to connect their experience with a patient like this plaintiff. I think that's your strongest argument.
that's
They say nothing.
Yes.
And so I think that's where they're deficient.
And I would agree with that, Your Honor. I think that this expert affidavit is vague and equivocal and doesn't specify the cardiac standards of care with respect to this patient.
Right.
If there's no further questions, I'll rest on my brief.
Thank you.
Thank you.
Madison Square Boys and Girls Club versus Atlantic Specialty. You may proceed.
Thank you, Judge. Good afternoon, James M. Catterson, Hillsbury, Winthrop, Shaw, Pittman, on behalf of Madison Square Boys and Girls Clubs. As I'm sure the court is aware, Madison Square has been around since 1884. They still, to this day, serve 5,000 kids in Brooklyn, the Bronx, and Manhattan for after-school programs and summer programs, all for the princely sum of $5 a year. They depend very seriously on donations. This case is a serious matter for them. Admittedly,
Well, presumably, it's a serious matter also for the individuals who are alleged to have been.
Justice Singh, you beat me to the admittedly part of it. Admittedly, the allegations in the complaint from conduct a half a century ago are horrible.
Counsel, isn't the issue here whether or not there's insurance coverage? I know this is all interesting background, but the real issue is whether this policy provides for coverage in the first place, and if it does provide for coverage, whether the exclusion excludes it. So why don't you first focus on, I know the primary argument in the brief is that this is vicarious liability case, and therefore this coverage under the policy. But upon reviewing the complaint, the lower court held, and why was it wrong in holding, that this is really a direct claim for direct liability for negligent supervision. So why would that coverage come in for vicarious liability?
Justice Kern, I would suggest that the Supreme Court conflated a lot of things in coming to that conclusion. First, Supreme Court conflated the exceptions in the policy. If you actually look at the policy, I know you have, if you go to page 131 of the record, it's endorsement 10. Endorsement? Yes, Judge.
are going to talk about the exception, but don't you first have to show that there is coverage in the first instance?
Absolutely, Judge. Endorsement 10 is a coverage section, not an exception. Endorsement 10 says that wrongful act is sexual harassment, including unwelcome sexual advances, requests for sexual favors, or other conduct of a sexual nature. And the carrier is liable.
So this sexual harassment would include digital penetration? Is that what you're saying?
No, Judge, not at all.
So
Not
what
at
does
all.
it include? Includes
Intentional
taking pictures of boys who don't have clothes on? That's sexual harassment?
Well, Judge, first of all, sexual harassment isn't a tort. We all know that. It's not a tort. There are a series of acts which constitute torts. Intentional infliction of emotional distress is the tort.
But in this case, it's the intentional acts of Antelucci and Archibald that we're talking about, right?
No, Judge, that's not true.
That's the question.
I beg to differ, Judge.
Okay.
If you look at the complaint, and I know you have, I can give you probably a dozen factual averments in the complaint that talk about the policies of Madison Square or talk about the actions of Madison Square's other employees, knowing about or not knowing about what Lefty Antenucci and Dr. Archibald did. The whole question here
That's a negligent retention. What you're arguing now, that's a direct claim for negligent retention. That's what it sounds like to me.
No, Judge, it's a claim for vicarious, that is a claim for vicarious liability. In other words, that there are employees of Madison Square who knew about the covered conduct and didn't.
And they allowed the employee to engage in this activity. That's negligent hiring and retention, no?
Why isn't this, let me add on to that, why isn't this failure to supervise as opposed to a vicarious liability claim?
Continue.
Thank you.
Continue.
Both sides have briefed. I'm loath to cite a case from across the river in this court, I really am, but it's a second department case that both sides have briefed. It's called Nivea T against the Department of Education. It addresses exactly this point. In Nivea T, it was a teacher who was molesting a student. And sure enough, the second department holds that the DOE is not vicariously liable for the actions of the molesting teacher. No question about it. But it appears that Supreme Court and my adversary didn't read the last page of the decision, because the last page of the decision says, however, Supreme Court should not have dismissed the vicarious liability cause of action, because the DOE can be vicariously liable for its other employees that knew about the molesting teacher and didn't do anything about it. It's directly on point. And like I said, Judge, both sides have briefed it. The whole question for you, one more second, Judge.
Go ahead.
The whole question for this court is there any factual averment in this entire complaint that points to negligent harassment? I would suggest, Judge, that there are tons of allegations in this complaint. Everybody wants to focus on Antenucci and Archibald. They are horrible. They're both dead and they're probably rotting in hell, deservedly so. But there is a whole list of allegations in the complaint about Madison Square's own failure knowing about some of those things. And let me finish by saying this. There is also a whole list of allegations in this complaint. I can go through the record sites. I don't have time, I won't. But where the complaint lays out conduct that is not sex abuse under this policy. Conduct like taking adult men on walks through the halls so they could see naked boys swimming. That's not sex abuse as defined by the policy. It may certainly form the basis of a negligent infliction of emotional distress for the poor kids that were watched by the guys wearing suits walking past them. There are a lot of allegations in this complaint that involve a lot of things other than the horrible conduct of Antenucci and Archibald. Thank you very much. I know I've gone over time.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Caitlin O'Rourke Gorman on behalf of Respondent. Based on your intimate knowledge of this particular case in the background, I'm just going to jump to the questions that you asked Judge Catterson and provide my client's response. Why isn't this sexual harassment imputed through the vicarious doctrine of vicarious liability, as you've asked? Well, I'm going to give you three very strong reasons I'd suggest. The first of which is that it's a claim for negligent supervision because that's what the allegations say so. And I'd refer your honors respectfully to pages 16 through 17 of our brief.
But is counsel correct that there are some allegations in the complaint that really relate more to vicarious liability, the example that was given with respect to men walking by while the boys were swimming?
Understood, Your Honor. So very good question. What about the allegations, Madison says, have nothing to do with sexual abuse? The swimming naked, the close-up pornographic photos that occurred, the lining the boys up naked outside Dr. Archibald's office. First, under our Court of Appeals test, Mount Vernon, which you are very familiar with, we have our but-for test. And frankly, but for the sexual abuse that's excluded here, in the sexual abuse exclusion, that is plain, clear, and unambiguous in this policy, there is no claim, there is no TB lawsuit, and we are not here. That's the first reason. The second reason is that these allegations give context, Your Honors, to the lawsuit, which is brought because of the sexual abuse. And Justice Edmeade used that phrase, context. That's exactly what she says. These children were abused, and the context of that abuse is that they were treated in this way. They were paraded around in front of adult pedophiles. The doctor took photos of their private parts, and as I said, he lined them up outside their office. Even if that doesn't constitute sexual abuse because there is no touching per se, it is part and parcel, and even better word to use, contextual for the true nature of this suit. Third, and perhaps most important, the exclusion, Your Honors, if you continue to read, doesn't only apply to sexual abuse. It applies to child abuse and neglect. Child abuse includes emotional injury, it includes emotional impairment, and it can involve risk to the child of physical or emotional health. This exclusion leaves no doubt that any of those claims relative to the pool and everything else clearly fall at the very least at minimum within the child abuse portion of the exclusion, and certainly in my view and my client's view, raised to the sexual abuse exclusion point. One more thing, if I could, Your Honors. This Madison itself, and this isn't controversial, I don't mean to be controversial, but they themselves characterize the allegations the same way. I'm going to draw your attention to Madison's brief at page 15 and Madison's brief at page 25. Quote, "These acts contributed to the children's emotional and psychological distress." Quote, "The children were put in extremely vulnerable positions in relation to Archibald." That's what child abuse is.
Thank you.
Thank you. May I address any other points, Your Honors?
No, we've got it. Thank you so much.
Thank you.
You may proceed.
May it please the Court, Christopher Bradley for Respondent, Philadelphia Indemnity Insurance Company. Your Honor, we've moved for summary judgment after Atlantic Specialty, and Judge Edmeade issued a separate standalone decision. Philadelphia's central contention is that Madison Square has left us with no argument. Their brief articulates no error in the decision of Judge Edmeade with respect to the excess insurers. And there's two points that Judge Edmeade makes in our case, in her written decision, which we contend there is no argument in the Madison Square brief. The first has to do with the fact that the policy is not an errors and omissions policy. It's an EPL policy. That is a part of the decision that Judge Edmeade said in our case, in the underlying case that was not argued in this appeal. The second point is that they do a very careful job of not obfuscation, not connecting the dots. The argument is not whether the theories are negligent this or harassment or this or that. This is interpreting the language of a policy. There's two ways, and Judge Edmeade was clear. There was no evidence of a wrongful act or a third-party wrongful act. And Madison Square, in their brief, uses things like may give rise to a claim, but there's never any articulation of how that would constitute the claim. It's not argued. So we would submit that it's been waived, and in our case, they articulate no error by Judge Edmeade with respect to the decision by Philadelphia Indemnity. And then lastly, Your Honor, the legal standard, there's no argument as to the legal standard, so that in toto, with respect to our standalone decision, there is no argument or articulation of error, and it should be affirmed.
Thank you.
Thank you, Your Honor.
You have 3 minutes.
Counsel, why don't you address the exclusion, which you didn't talk about initially? Why would the exclusion for sexual abuse and sexual misconduct and child abuse, which is extremely broad exclusion, not apply in this case?
If you accept my adversary's view that because of endorsement 13, which is the exclusion they're talking about, it's on 138 of the record, because it defines sexual misconduct to mean any sexual abuse, sexual assault, or molestation, because of that definition, then you have to write exception 10 right out of the policy. You have to. Because under my adversary's theory, there can be no coverage whatsoever because 13 abrogates all of 10. I would suggest to you that that's the exact opposite of the law in the state of New York, as we all know. In fact, I think every single member on this panel has sat on a case that said exclusions are to be narrowly construed. The policy is to be liberally construed in favor of coverage, and all ties go to the runner, in which case the runner is the insured. The problem also is the euphemism, my adversary uses a great word, I'm glad you brought it up, context. All of the allegations in the complaint are merely context. I would suggest the following. In a claim for relief, when you finally get to the provision of the complaint that is first claim for relief, it says, plaintiff repeats and realleges every allegation contained in paragraphs 1 through X above. Why does it do that? Because the claim for relief, in this case, the first claim, is based on vicarious liability on Madison Square. It marshals the factual averments to prove out the claim. There's no such thing as context. And I appreciate Supreme Court used that word. At the same time, Supreme Court conflated all of the actions of Antonucci and Archibald with every other single employee in Madison Square. There's no question about it. And so if you accept
So how should we read 13? Because 13 does refer to sexual misconduct or child abuse or neglect. The activities that you point to, at least one could argue, fall within that clause.
And that's exactly the point, Judge. When you said one could argue, anytime there's a legitimate disagreement.
Well, what's the disagreement?
The disagreement is, Judge, that I don't think there's any way, unless you're prepared to write 10 out of the policy.
So that's your best argument, essentially.
I think that's bedrock law in New York, that you can't write 10 out of the policy. Let me just add, before that red light goes on, which is the bane of my existence these days, before that goes on, my adversaries have devoted a lot of real estate in the brief to Mount Vernon. For the life of me, maybe I'm getting stupider in my old age. It's entirely possible. I don't understand it. Mount Vernon, as you will recall, give me just 1 minute, Judge. You will recall that Mount Vernon is a Court of Appeals case from 1996 involving certified questions from the Second Circuit. The Second Circuit said, we need to know if this exclusion bars another form of tort relief. And the exclusion was, it is agreed that no coverage shall apply under this policy for any claim, demand, or suit based on assault and battery. That's what it says. That's the exclusion. And so it was a premises liability claim. And so the circuit said, is a premises liability claim barred by that exclusion? Here's what the Court of Appeals said. The language of the policy controls this question. The language of the policy controls the question, and this is always the problem of citing insurance cases for their holding or their result as opposed to the particular principles of law enunciated therein, because every policy is different. Every single policy is different. The language of 10 is clear. You can't write it out of the policy. Thank you very much for your time.
Thank you. Friedco Capital versus Carlton Fields. You may proceed.
Thank you. Good afternoon, Your Honors. May it please the Court. Kristen Niven on behalf of defendants appellants Carlton Fields and Brian Hart. This action stems from a failed real estate development project, and as respondents admitted in their brief on appeal, the appellants did not cause this project to fail. They did not cause the failure of the acquisition of the properties that were key to the project. They did not cause the seller, Kygo, to decide to assign a part of the parcel. And they did not cause the respondents to elect to walk away and not close on the deal. This forecloses any claim for legal malpractice respondents could possibly make against the appellants based on this failed transaction. Now, if we look at the complaint itself and what it actually says, it does not allege any facts supporting causation sufficient to state a claim for legal malpractice. Applying every favorable inference, at best, respondents claim that Carlton Fields and Hart, their alleged inaction or silence on Southside River LLC's change in management somehow caused the respondents.
What about that partial assignment? Did that affect the ability for the deal to close?
No, because the purchaser of the 1/3, Kyle Family Investments, they were bound to the purchase and sale agreement. They were bound to go through and to sell their 1/3 along with the other 2/3 and deliver the parcel whole to the respondents as the purchaser, to Southside as the purchaser. So that was all understood, that was clear, that was conveyed to the respondents when they saw the draft assignment and were asked to consent to it. So that did not actually affect their ability to close. They elected not to close, as they admitted in their complaint. And that election is an intervening cause. They themselves are the intervening cause of this development to fail. And this is the only theory one could even glean in a generous reading of the complaint. Now, they go in a completely different direction in their brief on appeal, and that should be utterly disregarded because it's simply not in the record. It's simply not what they alleged in their complaint. But even if we were to allow some of those allegations in, say in an amended pleading, they're far too speculative to state a claim for legal malpractice. They allege that they would have won a $40 million verdict in the Florida court on their counterclaim for breach of the Kygo purchase and sale agreement, even though there was a broad language in the 1031 exchange that arguably at least permitted this assignment, and also the fact that they were the ones who walked away from the deal first. They didn't even claim that Kygo had breached the PSA through this assignment until after the date to close had passed. So there was at least a good case that Kygo had, and it was pure speculation that had it not been for this signed assignment, pure speculation that they would have won all $40 million of their alleged lost profits damages, which is also, as a matter of law, too speculative to form a basis for legal malpractice. If Your Honors have no further questions, I'll rest on my brief. Thank you.
Dow versus 16 Sutton, please. You may proceed.
Thank you, Your Honors. Tracy Peterson of Braverman Greenspun for the appellants. 8 of the 12 causes of action in this complaint were premised upon the validity of the lease amendment. That challenge was brought too late. It was time barred by the 4-month statute of limitations applicable to Article 78 proceedings. The motion court, however, declined on the motion to dismiss any of those causes of action, saying that they were all told and that the plaintiff's claim did not accrue until the date that she...
What about the argument that what she's really claiming is a breach of the proprietary lease rather than, rather than the passage of the amendment?
Sure. So regardless of how she characterizes her claim, what it is a challenge to corporate board action. This is the exact same issue that arose in Katz versus Third Colony. Judge Singh was the motion court judge on that case and recognized that notwithstanding that the plaintiff characterized the challenge as an ultra vires decision, what it boiled down to was a challenge to corporate action in enacting bylaw amendments and lease amendments.
Your position is whenever the challenge has anything to do with an affirmative action by the board, it's then precluded by the 4-month statute of limitations. It's not brought within 4 months of being notified of that action.
I'm sorry, Justice Kern, I didn't get the question.
Your position is that if the lawsuit has anything to do with an action by the board, you have to bring the action within 4 months of when the board takes that action.
That's correct. 4 months when the decision of the board becomes final and binding. And in this case, the action of the board was final and binding on July 1 when the plaintiff and all other shareholders were notified that the vote of the shareholders had enacted this lease amendment. And that it was...
What about the position of the trial court that it didn't become binding until she was actually charged the assessment?
Right, and this court has spoken to that issue as well. Again, in the Katz decision, in that decision, what this court had held was that notwithstanding that the plaintiff shareholder didn't have to pay the flip tax until 2012, the amendments that enacted the flip tax were years prior and more than 4 months, and that the time started to run from the date of enactment of those bylaw and lease amendments, not the date that the shareholder had to actually pay the flip tax.
Let me ask you something else, which may not ultimately be germane at this point.
Sure.
But the work that she's being charged for, is that actual facade work to repair the facade of the building, which is required under the local law 11?
What about it?
Is that what she's being charged for in this assessment?
To be honest, I believe that it is part of it, but not all of it. And I don't know that
You're
work
saying
has...
we don't get to opine on whether or not that would constitute a breach of the proprietary lease because it's time barred, and we can't even get to that issue.
No, you don't, for a whole host of reasons. One, because it's time barred. Two, because to the extent that plaintiff challenges the lease amendment's validity on the ground that it was enacted in contravention of the lease terms, she's absolutely incorrect. Looking at the lease terms themselves...
But is your argument that we don't get to that issue?
You don't get to it at all.
Are you saying that if a cooperative board amends their lease in a way that would be in contravention of local law, that there would be no relief unless a shareholder brings the action within 4 months? This court could not review whether your amendment flies in the face of New York City or New York State law?
That's correct. That's what the statutes of limitations are for. And
So I just want to be clear. You think a co-op has a right to amend their proprietary lease documents of their shareholders in a way that would be violative of New York City law? That you can make a change that would violate New York City law?
With all due respect, that's not an issue in this case.
But that's the question I'm asking you.
Yes, but the 4-month statute of limitations applies. There's a 4-month statute of limitations that applies to challenges to corporate board action. That's correct.
Okay.
If your argument's correct, you started to say that there were, I guess, at least 4 causes of action that don't relate to the breach of the proprietary lease. What are those causes of action and what would remain? The breach of warranty of habitability, what are the other ones?
Sure, and then the certain of the claims rest partially on the validity of the lease amendment. So for example, the breach of fiduciary duty causes of action and the fraud causes of action are premised on other allegations. For example, that she was fraudulently induced to purchase the apartment based on filings made by the co-op's architect or engineer to the DOB in 2011 and 2017. Would you like me to continue, or?
Are you satisfied?
I'm fine. You can get to it when you come back.
May it please the court. Isabel Knott of Wasserman, Grubin and Rogers for the plaintiff respondent. I'll open by addressing first Your Honour Justice Kern's point. Yes, absolutely. The impact of what the appellants are arguing is that my client would be personally liable for work that is required under Local Law 11. I would urge Your Honours to look principally at the record, page 346 to 47, in which the assessment supposedly issued in reliance on this amendment is titled Local Law 11 Project and includes...
How can we even get to the issue? What's your response to a number of cases that, from the First Department, which clearly hold that the statute of limitations when you're challenging an action taken by the board is 4 months? How do you get around those extensive line of cases?
Your Honour, there are 2 principal responses. The first is that the cases from this court recognize, including the leading case of Musi, which is cited extensively throughout the
leading
briefing.
case of?
Musi, or Musi, I'm not quite sure of the correct pronunciation. The Musi case makes clear that if you are challenging a discretionary authority of a cooperative board, then yes, you are bound by the statute of limitations set forth in Article 78. If, however, your claim is that the co-op or the board has breached an express covenant to an individual shareholder, giving rise to a breach of contract claim.
Where does Musi say that?
Musi distinguishes 2 key cases. The first case is Shapiro, and the second case is Del Terzo.
Well, I read Musi, and what I think Musi said...
And I was on Musi. And I was on it, and I don't remember it saying
so
what you said.
I think Musi distinguishes the cases you're relying on by saying that wasn't really an action by the board. One of them was the board failed to repair a roof, and the other one was that the board failed to give consent to something. So that was not actually an action taken by the board, where the case that you're talking about, Musi, was an action taken by the board, which they claim violated the proprietary lease. So why does Musi, how does Musi support your arguments? And this is a case, unlike the cases you're citing, where there actually was an action taken by the board, which plaintiff is claiming affected her rights under the proprietary.
Your Honour, I apologize if I've been unclear. My argument is not that Musi provides the foundation for my client's claim. It is that the exceptions to Musi apply in this case. The Shapiro case Your Honour mentioned.
Isn't that a case where the board didn't actually take action, it just didn't repair the roof?
It didn't repair the roof in violation of an obligation under the proprietary lease to do so.
Right, but in our case, it's not the argument, they talk about repackaging, but your basic argument is that the board took the affirmative step of passing this amendment, which affected her rights, unlike Shapiro and the other case, the state of Del Terzo, where the board didn't take any action, and that was the challenge.
Your Honour, I understand the distinction you're trying to draw. I would urge you to read the complaint, particularly the first cause of action at record 51. My client's claims are twofold with respect to the repair and maintenance of the terraces. First, there's a complaint that by way of neglect, historical neglect, the terraces were not repaired and maintained in accordance with the co-op's obligations. The second component is that the co-op is now trying to shift the financial responsibility for that past neglect onto my client individually. And the critical issue is not that the board suggested the amendment to the shareholders, it is that there is now an attempt to unilaterally alter the terms of the contract between my client and the co-op individually in violation of the contractual mechanism.
I guess I'm not following your argument. Why isn't that subject to a 4-month statute of limitations? So, for example, in Sicone, we said in 2019 that where the co-op amends the proprietary lease, that's subject to a 4-month statute of limitations. Doesn't that really answer this question here?
Your Honor, the breach of contract claim is twofold. The decision
Well,
to...
but that at least addresses your second point, right? That at least with respect to the amendment, where they're now the shareholders with terraces are responsible essentially for paying for local law 11 work. But doesn't that address that point?
Your Honor, the cases that support our position do recognize a breach of contract claim in a similar circumstance, where a proprietary lease is amended in violation of its terms.
And I'm sorry, which is the best case? Which case is the best case that supports you?
The best case that supports our position, the three cases are Shapiro, Del Terzo, and a case called Fellner, which was cited in the supplementary briefs below and is addressed in the motion papers. Those three cases all collectively recognize...
Does Shapiro, the other one is in an appellate case, but does Shapiro or Del Terzo involve an action by the board enacting an amendment or a bylaw or an actual action by the board?
No. Your Honor, I think that there's a conflation between passing a bylaw or passing a resolution impacting House rules or a bylaw and altering the terms of a contract. My client invested...
Isn't it doing it by passing an amendment?
No, the shareholders voted. Apologies, Your Honor. I apologize, Your Honor. The amendment was affected by a 2/3 vote of shareholders. That violated the agreement between the co-op and my client that any change to her proprietary lease that impacted her finances negatively in a way described in the briefs requires her consent. That is distinct, conceptually distinct from the board itself.
What about the flip tax case? I'm forgetting which one that was.
I apologize, Your Honor, which case?
Flip tax case.
Oh, that one is Katz.
Isn't that also a case where the amendment was passed by the shareholders, which impacted, and the claim was that the shareholders' rights were violated because the shareholders passed this amendment through the board for the flip tax, and they held that that was barred by the 4-month statute of limitations. How is this different from that?
This is different in several key ways. Principally, in Katz, the passage of the flip tax was years prior to the complainant, in that case, trying to do anything about it. The complainant was out of time for breach of contract as much as he was out of time under Article 78.
Wasn't the analysis under, it was a 4-month, the finding was a 4-month statute of limitations, right?
Yes. It was because the shareholder in that case brought a claim alleging that the board had acted ultra vires in charging the flip tax to him in respect of the sale of the unit. In that context, the 4-month limitation period applies. An ultra vires action by the board is in the nature of a challenge to corporate board action. But violating the terms of a contract by purporting to amend it in violation of the agreed mechanism to do so is conceptually distinct. And that is our key argument, Your Honors.
Thank you so much. Counsel, you have 2 minutes.
Thank you. The Busey case also was a shareholder challenge to a governing document provision that the plaintiff contended shifted financial responsibility for maintenance of terraces, and this court concluded that that was a challenge that needed to be raised within 4 months. None of the cases that were cited by plaintiff, or frankly by the motion court in its re-argument decision, dealt with a shareholder challenge to an amendment to any governing documents. They are all totally distinguishable from this case at bar. Justice Singh, you're asking about some of the other causes of action that would remain that wouldn't be time barred by the 4-month statute of limitations. And I had started to explain that the breach of fiduciary duty claims and the fraudulent inducement claims would be among those. They are partially time barred under different statute of limitations.
So you agree that breach of fiduciary duty could proceed? There is prior to July of 2017, there would be a bar to that.
Correct.
Okay.
Correct. And there are other issues and problems.
So why don't you address then the breach of fiduciary duty? What's the problem with that cause of action?
Sure. So the first, most blatant one is that it may not be asserted against the co-op because the corporation, as a matter of law, doesn't have a fiduciary duty to its shareholders. Secondly, it is based, at least in part, on alleged actions that occurred prior to the time that the plaintiff became a shareholder. So there was no fiduciary relationship in place prior to that time.
So it could only concern acts after July of 2017, essentially.
Yes. There are, most of the allegations supporting these claims are made upon information and belief without disclosing the source of the information and belief.
This is not a summary judgment motion. We're still at the pleading stage.
That is true, but that is still doesn't even meet the basic pleading standards of 3013 or 3016B. The who, what, where, when, why is just totally absent from the pleading, notwithstanding it's 50 pages and 270 paragraphs. There's a lot said, but not a lot of substance to what's said. My time is up, though, if there are further questions.
Thank you. Robbins versus 315 West 103 Enterprises. You may proceed.
Thank you, Your Honors. May it please the Court. My name is Richard Robbins, and I am a pro se plaintiff. I'm not a lawyer, but I imagine if you wanted to come up with a textbook example of a slap, this would be it. Today is exactly 1 year since defendants filed their motion to dismiss, and over 3 years since several of you heard the first appeal in this case. All I seek is my proverbial day in court. The lower court erred in comparing this case to Guerrero. In Guerrero, this court found that because the defendant's inflammatory flyers did not demand any action from government, it was not a slap. The Guerrero ruling specifically said the flyers did not demand investigation of plaintiff's alleged misconduct, using that as a gold standard of what is a slap. And that's exactly what I did. This couldn't be more of a blatant slap. Defendants argue the 311 calls were not related to the permit because it was 8 years old.
So what was the basis for the 911 calls, 311 calls?
They were all true statements of fact.
No, but what did you say? You complained about the work, the noise, et cetera?
I made true statements of fact.
No, I'm just asking you, did you
complain? There's a stop work order in effect and construction.
You complained about the noise, that work was progressing, they didn't have proper permits, that kind of stuff.
So 4 of the 5 were that there was work continuing in violation of the
what was the
stop work
5th?
order that was in effect on the permit. The 5th one was damage to my property by the construction.
Okay, thank you.
So they say that it's because it was 8 years old, but in fact, the permit had been suspended for 8 years, and because of fraudulent claims of vacancy in the original application for the permit, when DOB found out that the building was occupied, they suspended the permit. It stayed suspended. Before construction could resume, DOB told the defendants that landmarks approval was required. DOB then approved an application to reinstate the permit, but upon realizing that the recent application to landmarks was still pending, DOB sent a notice to revoke the permit and left the stop work order in place. But within 3 weeks of getting this notice to revoke, they moved full steam ahead with impunity with the project despite the stop work order. Also, LSG does not apply because it was a breach of contract issue that found that there might be merit to the case, to the underlying action. This underlying action, by contrast, had absolutely no basis in law. There was nothing whatsoever defamatory about my calls. I didn't post flyers accusing them of being funded by white South Africaners' money, like in Guerrero, or of being slumlords, like in New Line Realty versus Northwest Bronx. I didn't post on Facebook, like in Stellatus, or take out newspaper ads, like in Dwayne Reed. They didn't even know the particular words spoken, nor did I even mention their name, as Your Honor said was required for defamation in New Line Realty. Most importantly, pages 143 to 147 of the record have clear photographic and video proof that all the calls were true. But even after seeing this proof, they continue to act with impunity, saying in their recent brief to this court that statements like there's a stop work order at renovation site and there's definitely work being done are fabricated and false solely because no violation was issued. Of course, violations were subsequently issued for almost all of these issues. They also argue that it should be dismissed because I have insurance, which is inherently flawed, but also the statute clearly allows for punitive damages if there is no basis in law. And their intentions are clear. They offered to withdraw the case if I promised not to call 311 in the future. They said that they were seeking judicial relief for my calls to 311, which is really saying the quiet part out loud about what their intentions were. They also incorrectly argue that their status as an applicant isn't in the record, as my complaint didn't mention the application to landmarks. This is not true. It's on page 29 of the record. They argue it's settled law that Governor Cuomo suspended didn't toll the statute. The case they cited was reversed by the very same judge after the Second Department overruled.
Thank you. You'll have time on rebuttal.
Great, thank you very much.
You may proceed.
May it please the court, Stephen Wegg for the respondents. Your Honors, SLAP has, as the last two Ps, public participation. Now, it's clear Mr. Robbins had gripes with my client's construction and the construction that occurred before my clients even purchased the property years and years before. As we just heard.
So why aren't his calls a direct challenge to the application or seeking revocation of the DOB permit?
Because that's not what he asked for, Your Honor. What he asked for was for an inspection because of what can be characterized as alleged safety issues, things of that nature. He didn't call 311 and say, hey, landmarks, there's an application, don't approve it. He didn't go on the street corner and say, DLB, we're against this construction, we have been for over a decade, you should withdraw the permit. That's not what happened. What happened was there were 311 calls. Mr. Robbins said, my fence is caving in, or there's earth that's settling. They ripped off an order, but even though it was there, the DOP confirmed it. Those are the types of complaints that were made by Mr. Robbins.
So you're saying that if a citizen in our city believes that a construction crew is operating when there is a stop work order in place, that is not a legitimate 311 call?
I'm not saying that, Your Honor.
Okay.
I'm absolutely not saying that. Of course, the 311 system is in place for a specific purpose and for a very noble purpose, and that is for one of the reasons that you just said. What I'm saying is that when a person continuously calls 311, the DOB comes down, finds that there's no violation, that doesn't fall within the ambit of SLAP. That may be something else. It doesn't fall within the ambit of SLAP. And that's what the lower court found. It wasn't directly related to the permit. There was no time, for example, SLAP deals with public petitioning. It deals with people who, as Mr. Robbins did, and that's not what this is about, gathered up his neighbors to say, we don't want this construction site, we want to protest against it, we want to petition, we want to contact our local elected officials. That's protected by SLAP. This is something that's different. This is something that's just a two-way conversation between Mr. Robbins and 311. It wasn't made in the public. It wasn't directly related to the application. It didn't tell 311, withdraw the application, don't approve the application, withdraw the permit. It was solely about Mr. Robbins' private complaints about his neighbor's construction site, which is different than what would be public participation for SLAP under both the old statute and the new statute, which actually came out after.
Well, let me ask you, if a stop work order is issued by DOB, typically the construction or the developers, the construction company or the developers seek to have that stop work order lifted, right?
Well, they have to cure whatever caused.
They can't continue to work until they resolve whatever issue has been identified by DOB, correct?
Correct.
Okay, so can it be argued then that while you are trying to get a stop work order lifted, that he is commenting on on the permit and the application process, because at that particular juncture, you can't work. And by notifying the city that you are working in violation of that, I don't mean you personally, isn't that a form of testing and participating in whether this permit should be authorized to go again?
I would say the answer to that is no, Your Honor.
Okay.
What that would be seeking would be enforcement of an order, not the type of public participation involved in the permitting process.
Okay.
I think that there has to be a dichotomy between them, and I think that's what the law is. Thank you, Your Honors.
Thank you. Okay. Sir, you have 1 minute.
Thank you, Your Honors. That is a great point about trying to get the stop work order lifted. Another point, though, is that the statute doesn't only apply to applicants, it also applies to permittees. And as I mentioned in Guerrero, it directly says that calling to demand government investigation is something that would be covered, and says that Guerrero, the defendant, hadn't done that. Many cases that have found to be slaps have much less of a connection to direct outreach to government than this one. This is, again, a quintessential slap. This case would also make it so that any 311 call is actionable if the violation isn't issued, which happens in a great percentage of calls to 311. They didn't get caught. They got lucky on these calls. Many of the other calls, they did get called.
Except there was no finding here that calling 311 actually constitutes defamation. There was no such finding. Correct?
No, but there was a dismissal of the case saying that it's not a slap because, and LSG establishes that if the underlying case has a basis in law, then it might not be a slap, which is another important point, that most of the cases dismissed as not being slaps, or that are found not to be slaps, allow the case to continue. Here, by finding it not to be a slap, it slammed the courtroom doors shut, which is the opposite. And it's important that a plaintiff is able to seek redress, especially for a pro se plaintiff. Thank you very much, Your Honors.
Heritage Funding versus Doyle Brothers. You may proceed.
Thank you. Good afternoon, Your Honors. My name is Lester Channon from Farber, Brox, and Zane, and we represent Doyle Brothers Plumbing and Heating, who is a defendant in this case. Doyle Brothers Plumbing and Heating was clearly not created. It wasn't born, wasn't incorporated.
So we have this gentleman, Edward Doyle. Correct? Edward Doyle?
Go ahead. I have a hearing disability.
Okay,
so
I'll speak up. We have this gentleman, Edward Doyle.
We have an entity.
No, but also
Yeah, the owner is
individual.
Edward Doyle, yes.
What was Edward Doyle's relationship to the prior corporation?
I honestly don't know, other than what was shown in, what was indicated in the record.
So we
which
have
is,
in the record, for example, I guess a license number, so it's the same master's license number, correct?
Correct.
And it's the same one continuing today. Does that show that there's some sort of continuity of ownership, or at least raise an issue of fact?
We don't know who the owner is necessarily, since that's not been established in any way, shape, or form. In this case, they brought this case pure and simple as a negligence suit against Doyle Brothers Plumbing and Heating. They never mentioned the word successor. They never mentioned the word piercing the veil or merger.
Who would, counsel, who would know, over here?
I'm sorry, okay.
Yes, that's okay. Who would know what the relationship is between Doyle Brothers, Doyle and Sons, and Mr. Doyle? Who would know that?
I don't know. I suppose perhaps Mr. Doyle might know.
Perhaps Mr. Doyle. He submitted an affidavit in this case, didn't he?
Yes, he did.
And it was very, very, let's say, bare bones.
Very succinct.
Maybe a paragraph at most.
Well, a little more, but anyway, go ahead.
Mm-hmm. And did he explain in that affidavit what the relationship was between Doyle Brothers, Doyle and Sons, and himself?
There was no reason whatsoever for him to have done so because that was never raised in the complaint, never raised in the verified bill of particulars, never even raised in opposition to, well, we made the motion, so the affidavit was submitted before there was the op, but even in the op, they never say successor. The court below never mentioned successor liability.
Don't you think probably some discovery is needed to flesh that out?
Well, in a situation where the complaint and all the pleadings and everything in the case is completely bereft of one word about successor liability until we get up into an appeal situation and all of a sudden they start raising these issues. The only thing they said below was, we need discovery just to explore the relationship.
Well,
no word, nothing about why they need it or anything.
But why is that an unreasonable request?
Well, first of all, they've never, in 3 years, they've not served one whit of discovery demand on us to begin with, which shows how disingenuous that statement is. Perhaps if this suit, if they hadn't made Doyle Brothers jump through 1,000 hoops, served notices to admit that they failed to respond to, that showed that the work was done before 2008, long before the inception of Doyle Brothers. I mean, the entire suit was brought in one vein, and all of a sudden, at the last hour, 3 years into this, they start talking about something that hasn't even been part of the case.
Counsel, did Mr. Doyle provide any information in the affidavit as to when the work was performed? Because obviously, not only would he know the relationship between him and the entities, but certainly when the work was performed, because I know there's an issue with that.
He did not mention it, except the papers made the point that the work was obviously done in, between 2005 and 2006, since the permit that they produced indicates that. We didn't raise what we viewed was extraneous issues that they had not brought up in the pleadings and verified bill of particulars in their papers, and there was no point in raising issues that were not germane or not germane to the case. They hadn't raised these issues. So
Discovery would certainly bear that out, though, correct? I mean, discovery would bear that out since we don't know.
I don't know what discovery would bear out, but conceivably discovery would provide some illumination on some of these issues. If this was a lawsuit that was a successor liability lawsuit, which it absolutely is not.
Okay, you'll have time on rebuttal. You may proceed.
Good afternoon, Your Honors. I am Richard Freilich, associated with Clausen Miller for the respondent, Heritage Funding. When I was a law student, I was a clerk for Judge Stackhouse when he was in the civil court. And Judge Stackhouse had a law secretary, Ann Gardner, who would hand me assignments to work on. And one of the first assignments I was handed to work on was a motion for summary judgment. And I had taken New York practice. I kind of knew what a motion for summary judgment was. But I had never heard of a notice to admit. So I'm looking at this, and what's going on here? They defaulted on the notice to admit. Do I have to grant the motion for summary judgment? She said, no. No, they're asking for the dispositive facts of the case here. And you know what you call it?
Counsel, your adversary essentially contends that you sued the wrong party. You never made the claims of successor liability or continuous ownership. Why should we allow you to do that at this juncture?
Successor liability is not a separate cause of action. There's not a separate cause of action for successor liability. They're Doyle brothers now. They were Doyle and Son then. There's Mr. Doyle. I don't know why. Counsel doesn't know why Mr. Doyle changed the...
Well, but you had 3 years, according to counsel, to ask for discovery on those issues, and according to counsel, you did not.
Discovery still has to be done, Your Honor. There was a pandemic in the middle. There was.
Well, in any event, it wasn't a 3-year pandemic.
Yes, Your Honor, to go on. When when I was discussing that motion years ago with Ann Gardner, you know what she called it? She called it
Counsel,
sharp practice.
I really, it would be really helpful if you just focus on the issues of this case.
Yes, I'm getting there.
I think it would make for a stronger argument.
Okay. Your Honor, my point here is this is sharp practice. They're using CPLR 3123, the notice to admit, as a backdoor to get summary judgment. Instead of having a sufficient affidavit supporting their contention that there are no triable issues of fact and they're entitled to summary judgment, they did not do that. And unless Your Honors have any more questions, I have made my point.
Thank you. Counsel, you have 1 minute.
Well, I think really the only point that my adversary made that I think whatever I feel impelled to respond to is the notice to admit issue, which is the court below said that it was an ultimate fact concerning timing. First of all, I cited 3 cases with parentheticals about what was going on. They each involved timing in a litigation situation. And in each of them, there was a notice to admit, or the courts found that a notice to admit was proper. Timing is incidental to the nuts and bolts of what this case is. It's a negligence suit. You know, was there negligence that happened? When this happened, I mean, it's kind of an absurd notion to think that the owner of a building that had major construction on it in a particular year doesn't know when this happened. This is not an obscure fact. And so this is not an ultimate fact. It's an incidental fact to this case, and it essentially exonerates my client because it demonstrates.
So then it's not incidental, is it?
Well,
thank you. Saeed versus Shaki. You may proceed, sir.
Thank you, Your Honors. May it please the court, my name is Stephen Uden. I'm with the law firm of Bernard D'Orazio and Associates, and we represent the appellant in this case. Your Honors, this is a very straightforward case. Our client, the appellant, is merely seeking the same relief through the courts that he was given in arbitration. Unfortunately, the relief has been elusive, frustratingly elusive through the courts.
The bottom line is that there was an error in the proper amount of the judgment. That's really what this boils down to.
It does boil down to that. I mean, and the error really stems from the fact that there were 2 decisions at the trial court level. The first one was very vague and it didn't have any specifics. And on resettlement, we sought clarification. And the judge granted the motion for resettlement, but only partially clarified the prior order and said, okay, you are entitled to contract damages plus interest from the date of the arbitration award, but omitted 2 other components of the damage award, which was not inconsequential because it amounted to almost $100,000 of the damages. And that was for inventory on hand and reimbursable expenses.
Right.
So the judge on the motion for resettlement could have and should have, we argue, fully clarified his prior order and awarded the full amount of damages that were awarded in arbitration. But mistakenly, he did not.
So what you need from us is a correct judgment with the right amount.
Exactly.
Correct?
That is correct. That takes into account the full award at arbitration.
Yes. Got it.
Yes.
We understand you completely.
Okay.
Okay? Thank you.
Thank you very much.
Have a good day.
You too. Thank you.
People versus Kermar James.
If it was always that easy.
I was like, I love your songs.
Good afternoon, Your
Good
Honors.
afternoon.
Barbara Zolot for Appellant Kimar James. May it please the court.
Before I get started, I would like to alert the court that today I uploaded a supplemental citation to NICEF, a case that was decided just today by the court, People against Maximo de la Cruz. With the court's permission, if the court wants, I do have hard copies
Sure.
to hand up.
Thank you.
Thank you. Thank you.
I can assume you've given your adversary?
Yes, I have.
Fabulous, okay.
Your Honors, here the prosecution failed to prove the element of serious physical injury requiring dismissal or reduction of Mr. James's conviction for first-degree robbery.
I find it really hard to hear that argument when we're talking about somebody with a broken jaw.
Understood, Your Honor. Colloquially, and to a layperson, of course, a broken jaw is a serious injury.
But it was broken in two
However-
places, not just one.
With the metal plate and screws.
Correct. However, what's important to focus on here is that what the penal law and the common law require, it's a very rigorous standard requiring proof of a continuing serious impact on the health or appearance.
Does it require a permanent injury, just a protracted injury?
Continuing and lasting impact. And here, what I'd like to focus on is that the broken jaw was surgically repaired the day after with successful surgery. And what's very significant here is that the surgical procedure did not require the complainant's jaw to be wired shut after the completion of the surgery. This is a central fact in all of the cases cited by the people, and in particular in People against Wilkins. The complainant's jaw was wired shut. And in Wilkins, what that meant was that the complainant, for months afterwards, was restricted to a liquid diet, suffered significant pain, and was unable to work. Here, by contrast, what we have is the complainant's testimony that he was restricted, he had to have liquids for days that followed. He missed 8 days of work. He did not testify at all to continuing pain. He didn't testify to any continuing impairment of his function. Yes, it's true that there were metal plates and screws inserted, but again, there was no evidence or testimony that that created any interference with the complainant's ability to function, to open and close his jaw, or to eat. In fact, it appears that the surgery restored function without any adverse effect. The people didn't put in any medical records, pertaining to the follow-up visits, suggesting that there were any ongoing adverse effects. Yes, the doctor cited potential effects, nerve damage or infection, but there was no evidence that any of these consequences came to pass. So what you have here is...
This issue is not preserved, though, right?
It is not preserved, but this court has reached it in the interest of justice, and such as in People against Sudol. And of course, if the evidence is sufficient, the verdict is insufficient or inadequate. The verdict is necessarily against the weight of the evidence, and this court is empowered and must exercise that review power. The absence of proof should lead this court to conclude not only that the evidence of serious physical injury was insufficient, but that, in fact, there was no protracted impairment, which is what's required, because otherwise the prosecution would have put in the evidence to show that protracted impairment. And I mentioned the case that I handed up this morning. It provides such a useful contrast. I mean, there's Wilkins, which is very directly on point, since it shows the difference between a wired jaw and one that isn't, as in this case. But in that case, Maximo de la Cruz, this court said, true, the impairment doesn't need to last years or be permanent, but it must be protracted. And there, the complainant's hand injury meant that she testified she was totally unable to care for herself for months afterwards. She needed a home health aide. And
Can we not infer from the photographs of what his face looked like after the surgery, the description of what it took to repair his jaw, and infer from that that he had to have had serious discomfort and serious sequelae from his injury, because the case law doesn't require any set period of time, doesn't require months of protracted inability to eat solid foods. It doesn't require any of that.
2 points, if I may.
Yes?
The statute doesn't require any specific set of time, but it does require it be protracted, and here we have testimony and evidence that just references days. And while
Right, but the fact that somebody has to go back to work after 8 days just means that they have to earn a living, that they have to pay their rent and support their family. That, to me, doesn't say anything about what he was experiencing, right?
Well, the problem
and
is...
having having a metal plate and screws put into your mouth certainly doesn't abate after 8 days.
Well, but the problem here is that there certainly would have been evidence that the people could have produced. So we're inferring from a record that doesn't exist. And the
we're inferring from the nature of the injury.
But the
I think that lets us infer. I mean, if somebody were unconscious for 2 or 3 weeks, it doesn't, you could still infer that there was, without them being able to speak on it, right?
I think I disagree, Your Honor, because, and I point the court to People Against Phillip, a case cited in our brief where the complainant's jaw was not wired. Yes, it was unpleasant, but it did not mean more than unpleasant. I'm not minimizing it.
Yeah.
But that appellate court, not this court, said, we're not minimizing it, but this does not meet this very high standard of serious and protracted impairment of health or function. And the evidence here, it simply isn't here. The people didn't produce it.
All right. Counsel, we'll hear from you now. How do you make out the serious physical injury here?
2 ways. Shira Knight for the people. Under protracted impairment and also under protracted disfigurement.
The disfigurement, I don't see how you get there on this record at the time of trial. There was nothing disfiguring about him, was there?
There was. His face was swollen, and the people provided a photograph of the victim before the incident, at the time of the incident, and about a week later. And at that time...
Well, yes, a week after having your jaw broken, of course you're going to be disfigured, but you have to be disfigured for a protracted period of time. So at the time of trial, he was no longer disfigured the way he was immediately after this incident.
He testified that my left side of my face is still swollen. Where he was punched, it's still swollen.
Okay.
And the jury saw a photograph of what his swollen face looked like after surgery, about a week after surgery. And they saw him at trial.
Okay.
Was there testimony with respect to the pain and suffering that he felt for a period of time, the medications he took, et cetera, et cetera?
Yes, he was
for
given...
what period of time was that?
Yeah, he was given intravenous morphine in the hospital, and he was discharged with another narcotic pain medication.
And how long did he take that medication?
It does not state how long. However, the record does state that he had 6 to 8 weeks of post-surgical care. And just to stress again, he had permanent metal plates and screws affixed to his jawbone.
I get that. You know, this would have been very easily resolved by asking him a simple question, right? Do you still feel pain? It's a simple question. I don't understand why that is not a part of the examination in making and creating your own case.
I understand that. I agree. But the record still does support serious physical injury. The jury could see him, It isn't an issue of fact for the jury to decide. The jury was.
Do we have a photograph of what he looked like at the time of trial? Because a swollen face does not equal disfigurement.
However.
Unless the face is like swollen like a football.
Well, I could show you
Okay.
what he looked like when he was saying how his face was still swollen. So that was his testimony. My face is still swollen. And they had showed this photograph. And it is disfiguring. Half of his face is
that
much
photograph- I'm
larger
sorry,
than
is
the
that-
other half.
Is that photograph, is that in the record?
Yes, it is. It is, and I did provide it to the court as well.
It shows swelling. To me, that doesn't show disfigurement. Disfigurement is a really, really high bar. You don't look at that face and go, oh, shock, disgust. No, it's not that. It's, wow, one side of his cheek is a little more swollen than the other. That does not equal disfigurement. So I don't think that's your strongest argument.
Okay. Well, the people do make out serious physical injury under protracted impairment.
Is that photograph of the complainant at trial or at the time that he was assaulted?
This is at the time he was assaulted, and this is about a week after surgery. But his testimony at trial was that his face is still swollen, and it is on the record. It's not a silent record like McKinnon. He did state, this is the left side of my face. It's still swollen. And the jury was given instructions on serious physical injury. It was an issue of fact for them, and they determined that he did suffer physical injury, serious physical injury. And just to show you the x-rays again, these are displaced fractures. It's not a line fracture. These are displaced fractures in two separate parts of his jawbone. And his injuries—
Counsel, I don't think anyone here disagrees that that was a serious injury. The question is, was it established at trial that this was a serious physical injury under the statute as it is defined, right? And all it required was a few extra questions about his ongoing difficulties based on his injury.
I believe that would have helped, but we still did make it out. As you stated, impairment does not have to be permanent. There's no set time limit. He missed 8 days of work. He could not eat solid food for a time afterward. 6 to 8 weeks of post-surgical care. He was on powerful narcotic medication. And his injuries did warrant having his jaw wired. He chose an alternative treatment in which he had permanent metal screws and plates affixed to his jaw.
So that's
those
it.
cases
That's
are
it.
applicable.
What you just said, are you saying that the plates and screws were the option he chose instead of the wiring?
I believe so, yes.
So that is another way to achieve the same result of realigning and giving time for those bones to heal?
Yes.
Okay, thank you.
Thank you.
Counsel, you have 2 minutes.
Counsel, do you agree that there were 2 displaced fractures to the jaw?
What there were, yes, in a sense, there was a mildly displaced fracture, and then there was a displaced fracture.
There were 2 displaced fractures.
There were 2 displaced fractures. The plates and the screws repaired that, and the plates and screws did not themselves, or I should put it, there was no evidence that the plates and screws, the complainant didn't testify that caused him any discomfort, significant pain. He may have had discomfort necessarily.
I don't know anybody with plates and screws who doesn't talk about the pain and the discomfort of having plates and screws.
But the complainant did not testify to it at trial.
I agree.
And
that's the problem.
Nor to any adverse effects, such as being unable to open and close his jaw properly or unable to speak properly. There was no evidence of that kind at all. So what we have here is a serious injury in the sense that we all understand it, but that did not create a serious and protracted injury in the way the penal law requires on this record.
Okay.
Thank you.
Thank you. Okay, Salvatore Laporta versus PPC Commercial. You may proceed.
Thank you. May it please the court, I'm Steve Arapach for plaintiff appellant. Plaintiff should have been granted summary judgment under Labor Law 240 because corroborated affidavits established that a defective ladder toppled beneath him. The case was not premature because this case should be decided like the First Department's decision in Erkan, where the motion court had initially denied summary judgment on the basis that it was premature, but this court held that the fact that the plaintiff had fallen off a ladder that toppled beneath him and was established by the plaintiff's own affidavit, which was presented.
Why shouldn't there be an EBT of the plaintiff, maybe if there are any witnesses, I don't know, before the motion for summary judgment?
In this case, there was none because the defendants initially adjourned the plaintiff's deposition, and then once the pandemic started, they refused to conduct depositions.
Well, did you offer an EBT of your client? A video EBT, I think.
We offered video. We offered that we would conduct a bifurcated EBT where...
And the bifurcated EBT was by video, or was that in person?
By video. We were, whatever they would do, but everything that we tried to do, they refused. And the plaintiff, in this case, this is even stronger than in Erkan because in Erkan, the plaintiff offered just his own affidavit in an unwitnessed accident, and he moved months before depositions were even scheduled to occur. It was the PC order set a date that was like 4 months later than plaintiff moved. And this court held that it's such a clear-cut case, as it is here, that summary judgment should issue. Okay. Unless the court has any other questions, I'll...
Okay, you'll have time on rebuttal.
Thank you.
Good afternoon. May it please the court. My name is Paul Tarr, counsel for respondent. This is what this court is being asked to do. This court is being asked to overrule the trial court and to find that PPC had...
The issue is whether it was an abuse of discretion, I guess. But,
exactly.
But so your adversary says, and I do recall reading from the record, that there was, he had further surgery coming up, so there were issues with respect to maybe damages, offered you a liability deposition. Why did you not engage in that?
A few reasons. One, we did not want to, my client and the email exchanges between counsel indicate we wanted a single deposition.
Why? What does it matter? Because we're talking about liability here. That's a 241 case. That's all we're discussing on the summary judgment motion, right? It's liability.
Economy of effort, Your Honor. I mean, yes, it could have, they could have agreed to something, possibly. It was not impossible, clearly, to conduct a remote deposition, but their disinclination to do so. PPC's...
Let me ask you. You have to show it's premature. You have to show there's some discovery you needed that you couldn't get that makes it premature. The two issues are whether it was repair work or retrofitting. Why couldn't you get all the information about retrofitting from Macy's, which was indemnifying your client? What discovery did you need that was not available to you to show that this was repair versus retrofitting? What would plaintiff know that you didn't know to take this out of 240?
Plaintiff would know precisely the nature of what he was doing.
Why wouldn't Macy's know? Macy's contracted out this work to have the work performed. How could Macy's not know what work they were having performed in their own department?
That question would be better asked of Macy's, but
right,
my
but
client
Macy's was indemnifying you, so you clearly had access to Macy's employees in terms of gathering information for this case. What evidence could you not get that you needed to get to oppose this motion?
I refer the court to the exchange between the counsel in the record, whereby we make clear to plaintiff's counsel that Macy's had furloughed its employees, and that
Right,
employees
but there's
who...
been a lot of time since then, too. You can't not litigate a case forever saying employees are furloughed and therefore we're not going to engage in discovery in a case.
That is correct, Your Honor, that is correct, Justice.
And I
but-
can't imagine that Macy's hired this construction company without a written contract.
Presumably, but I only have the record before me. My client did not forfeit its right to discovery it needed because it was disinclined to have a bifurcated liability only.
I guess I don't understand it. I honestly, we're going through a pandemic. Everything, including court, is on video, and the attorney just decides, well, I don't have to do this. I'm not going to do this, and that's sufficient.
Not to do it. No, I wouldn't characterize it like that, Your Honor.
Because your concern, obviously, the issues that concerned you are the issues you raised. What my colleague raised, is this a repair? Is this an alteration? Those are, you could have got all that information from the plaintiff in a timely way had you chosen to do so, and you chose not to.
We made discovery demands. What we simply did not want to do was have a bifurcated deposition, and our preference for that is not a forfeiture of our right to discovery. The trial court got it right.
Nor is that choice a prohibition from making a summary judgment motion where there are no issues that have been raised, really.
The issues that have been raised were the nature and the manner in which plaintiff conducted his work that could be teased out, extrapolated through deposition of plaintiff and deposition of coworker in a way that could never be elucidated.
Held.
I beg your pardon?
Then the deposition should have been held, and there was certainly no reason not to depose the co-workers who were witnesses to this accident.
Your Honor, respectfully, I repeat, the way in which the dispute over discovery was conducted here is not a forfeiture of our right to that discovery.
I heard that argument. Thank you.
Thank you.
You may proceed.
The only thing I would add is that the evidence is actually completely clear that this was alteration work. It was three guys working for 3 months to convert fluorescent lighting fixtures throughout the entire Macy's to an upgraded LED kind of lights.
This wasn't a changing out of light bulbs.
No, it was
This was
rewiring.
removing and then reinstalling new light fixtures in the entire Macy's.
Correct. If there's anything else? No, thank you.
Thank you.
Thank you, Your Honor.
274 Madison Company versus Vieira. You may proceed.
Thank you very much. Paul Gruber from Bora Goldstein, Altshuler, Naines, and Goydell for the appellant this afternoon. It's significant to note that the underlying rent default for which we're asking the guarantor to answer occurred in November 2019, about 4 months before.
Counsel, I already have a question about that.
Sure.
Because you phrased the default as a failure to pay rent, but the default for which you are seeking the acceleration, which is not just month to month, is based on the surrender. And your argument that surrender is invalid, but that occurred actually during the period when the administrative code provision was in effect. So the alleged default, which is the basis for your seeking rent going forward, was based on a default that occurred during the period of the administrative code. So why shouldn't the administrative code, which by its plain terms applies to defaults during that period, not bar your claim for that accelerated rents against the...
We started this action against the guarantor in February of 2020.
But that was only for months, and you got summary judgment.
We got summary judgment for that period.
Summary judgment on the rent up till the administrative code went into effect. The question is whether or not you are entitled to the accelerated rent based on what you claim is an ineffective surrender. So then the question is, when did that default occur? That default which entailed you could not have occurred before the tenant surrendered, which clearly occurred during the period of the statute.
Well, I'm not going to use the word surrender because I think everyone agrees the court found there was not a proper surrender here.
We're not
It
agreeing.
also occurred
We're
at a,
not agreeing to anything, so just,
right,
there's
I
no
understand
record here, but no one agreed to that. That's your position.
that we respectfully disagree. And also at the time, we had a judgment of possession and a warrant of eviction against the tenant. With respect to the guarantor, this tenancy was effectually over. The tenant essentially moved, gave up, surrendered in the common sense of the word. And the question becomes what the intention of this statute was. We point to the legislative history here, and this is repeated a lot in the Melendez case, which was
Did you argue, and I'm sorry to interrupt you, just occurs to me, you're not making the claim here that it's unconstitutional?
we raised the issue, it hasn't
Are
been.
you making the claim?
We are not arguing that here today.
I just looked at the brief very carefully. You don't make the argument. You can see
We don't,
that?
we don't. You
Well,
know.
let me ask you, because your primary argument seems to be that it ceased doing business during that period, and they should not get the benefit of the administrative code where there was a complete stopping of business as opposed to a temporary hiatus. Where in the administrative code does it make that distinction that you are trying to create?
It comes out from the legislative history of the statute where there was very clear discussion that it was the intent of the council so that once everyone got that past that period, we went back, there would be businesses for people to go back to.
Is there anything
There is
in
also-
the language of the statute itself which supports your claim that a distinction should be made between a company that goes out of business completely versus a company that has a hiatus?
Yes, it does, because the statute does refer to the executive orders. Now, the executive orders with respect to this particular business didn't say that this particular business must close. It had to reduce its staff. It could continue to do business. Lots of businesses did. This was a school. It may have not been allowed under the executive orders to have people in the premises to conduct live classes.
So then how does a school function if it can't have?
Public schools somehow managed.
Well, but in this business, and what the guarantor says is that she was unable to function in this period, and
Oh, that's
therefore
what
she
she-
shut down.
That's what she says.
There's
and
nothing disputing that.
Right, and there was also a judgment of eviction, which, but for the
Counsel,
moratorium.
your argument is that in any business that's shut down as opposed to at a temporary hiatus, no guarantor could take advantage of this administrative.
If they permanently shut down, a temporary might be, a temporary would present
If any of them
different.
ultimately shuts down, whenever that decision is made, then they don't get the benefit of this.
That is our position, and I think it's borne out by the history of the
Are
statute.
there any
and
cases that support your position? Are there any cases that analyze this issue?
At this point, I think we're the first impression here. There are a couple of cases we cite in the reply brief that are all lower court at this point that stand for the proposition that if the default occurred prior to the enactment of the statute, it's the benefits of the statute don't. There's one case from Judge Bluth. Bluth, she has a lot of cases on these issues, where she held that it wasn't designed to protect an office tenant such as this one. It was more concerned with the retail and personal care trades.
But I'm looking at the plain language of the administrative code, and all it says is the tenant was required to close to the members of the public under the executive order. Isn't that what happened here? Because members of the public were now not permitted, i.e. students were not permitted into the premises.
I understand your point, Your Honor, yes. But I mean, our position is that, you know, there's clear, that the statute has, you know, makes references to other orders, and those orders really weren't really completely allowed this tenant to do business, albeit not in the premises.
Counsel,
and
if
that
I
this
may,
is-
because you're talking about the legislative intent.
Right.
And I don't recall that argument being raised below. Was it raised below? Because I don't recall that. That's a yes or no.
No, I don't think we raised it this in the same way we raised it here. Certainly, this is something the court could consider. You know, it's not a new fact.
All right, you'll have time on rebuttal.
Yes, I will. Thank you.
Good afternoon, Your Honors. May it please the Court, Law Office of Jordi Fernandez for Respondent Christine Vieira. Your Honors, at this point, we're asking the Court to affirm the lower court decision and find that the Administrative Code 1005, also known as the Guarantee Law, removes the respondent from liability or precludes liability after March 31st.
But isn't there a fair argument to be made that the default occurred earlier, and why should you get the benefit of the statute?
No, there's not.
Oh, and why is that?
There's not, for a few specific reasons, Your Honor. Number one, the clear language of the statute does not do that. It does not exclude businesses that were in default prior to the pandemic, and there was an opportunity to do that. This is a legislation that exists to prevent financial ruin for guarantors, many of them being small business owners, from having to file bankruptcy after their businesses were.
So what occurred during the operative period that allows your client to take advantage of this provision?
Her business closed. This is a language school, I should point out. So there was an in-person language school where they taught classes in person. The students went to the school and they sat at a table and they engaged in conversation in Portuguese. Brazil had language school. It's a Portuguese language school. Our world turned upside down after the closures, after the pandemic. That couldn't exist. To the extent that the appellate raised, other things could have been done and other things could have been stayed in business. I mean, that's not just something that my client alleges. Excuse me. My client just doesn't allege that her business was affected. Many businesses in New York were affected. That's no surprise to anybody. We all lived through the pandemic. The City Council knew that when they enacted the statute on May 26th of 2020. That's a few months into the pandemic. They knew many people may have been in default beforehand. They knew many businesses would close, and they did not create an exception for that. In fact, if you look at the legislative findings, the plain language of the legislative findings and declarations, and if you look specifically about that, they specifically talk about some of the arguments raised by Appellate. The fact that her business closed and she did not weather the storm of the pandemic does not preclude her from seeking the protections of the Guarantee Law. Paragraph 4 of the legislation, declaration, and finding explicitly discusses the numerous closures in businesses and loss of jobs. Paragraph 6 explicitly acknowledges that the business closures would be inevitable. And the language they use in paragraph 6 is that there's a hope that all the businesses would not close at once. So that clearly doesn't bar a business that closed, and it didn't bar a business that was in default prior to the
But what about rents owed after the operative period? Why wouldn't the landlord be entitled to those rents?
That is specific. That's a factual determination made by the Supreme Court in this case, and that is specifically related to the acceleration clause in paragraph 18 of the lease. So in this case, they commenced this case in February 2020. What the Guarantee Law says specifically is defaults occurring from March 7th, and then later it amended all the way to June of 2021. Those defaults are excused. So they commenced the case in February 2020 while she was in possession. On March 31st, 2020, she turned in the keys. She vacated the premises. Then the appellant moved for summary judgment based on an acceleration clause, and they sought
the default occurred. So your position is the default occurred in the period, and therefore
on March 31st, and that's the determination of the Supreme Court as well. And the basis of that is because that's how plaintiff proceeded. They sought to accelerate the lease based on a default that occurred on March 31st. That is their characterization of it. They're stopped from challenging that now. They can't change that position here and now in this appeal. That was their position, that because of the default, they're entitled to the acceleration of the rent all the way through the expiration.
So if they had waited to accelerate after the period was over, is it your position that your client would be on the hook for those monies?
I think that if I'm understanding your question correctly, had they waited to seek August 2021 rent in August of 2021, would that have been proper at that point, and would that have fallen outside of the scope of that? The answer to that is probably yes. They characterized it as an acceleration, as a default that occurred on the pandemic, But also consider the practical implications of that. What she did, and appellant raises that there was a judgment of possession. There was also a moratorium. The landlord couldn't do anything with that judgment of possession. There couldn't be an eviction. What my client did was turn in the keys. They voluntarily turned in the keys to stop as much harm as possible, both for the appellate and both for herself.
Do you want to address the issue of the surrender not being in accordance with the specific provisions of the lease?
It's an interesting issue, Your Honor, and we did withdraw our cross appeal that dealt with that beforehand, but I will address it briefly. That is not the language of the guarantee agreement. And this was an individual, and the other side was a corporation. And what they did in that language of that guarantee agreement is they completely left out the language of that they needed to seek approval first, that the tenant needed to seek approval first and have a signed agreement for a surrender with the landlord. That comes from the language of the actual body of the lease, but not the guarantee agreement. So just in looking at the language of the guarantee agreement, she was completely in compliance with the guarantee when she gave up, when she turned in the keys.
Well, I wouldn't go that far.
Well, yes, I think what you're suggesting there is she went maybe the broom clean condition and she turned in the keys. Okay. I won't address that anymore. Thank you, Your Honor.
So much.
Thank you for your time.
The issue of whether the surrender was properly effectuated was decided by Judge Hom, and his client withdrew their cross appeal on that. We have the law of the case there with respect to that. The guarantee refers to that it has to be in accordance with the lease. That's clearly didn't occur here. In fact, they didn't remove their possessions until June of 20.
When did you accelerate?
This isn't an acceleration clause. I don't read it as such. This is a clause that this is a liquidated damages provision with respect to if there's a default under the contract, the landlord could also ask for A, B, and C, and D.
Without accelerating, you couldn't do that, right?
Well, this is the terms of the agreement, and this court has upheld similar things, similar provisions in the past. We cite the cases, and the liability of the guarantor, survived the tenant's departure from the premises.
Thank you so much.
Thank you very much.